Marcus had been out of work for 6 weeks when the calls started. His employer was pushing him to return to work, and in North Carolina workers' comp cases, they often turn on exactly this moment. Marcus came back. He re-injured his spine 2 days in. By the time he reached settlement with the insurance company, they had cut his permanent disability payout in half. What I'm going to show you today is how this pressure tactic works, what the law actually says your employer can and cannot demand, and a legal protection under North Carolina statute that most workers never know about until it's too late. Here's what I have seen happen over and over again in 40 years of handling workers' comp cases here in the state of North Carolina. You get hurt on the job, you file your Form 18 with the North Carolina Industrial Commission. Your employer reports the injury to the insurance carrier. Insurance company starts paying your wage replacement benefits, which under North Carolina law are 2/3 of your average weekly wage. And then a few weeks in, the calls start. Sometimes it comes from your supervisor. We miss you on the team. Sometimes it comes from the HR. We have a modified duty position available with no heavy lifting. And sometimes the pressure comes from the insurance adjuster directly, framed as a concern on their part. Our medical records indicate you may be ready for light duty work. None of this is accidental. The insurance carrier is paying your wage replacement benefits every week you are off of work. Every week costs them money. If they cannot get you back on the job, even in a modified role that barely resembles your actual position, those weekly payments stop, or at least they get reduced. That is the financial calculation driving every one of those phone calls. Your employer often cooperates willingly. They may genuinely need someone on the floor, but they are also being pushed by their insurance carrier, who is monitoring their claim costs and looking for any opportunity to stop the bleeding. The employer and the carrier are working towards the same goal, and it is not your recovery. What I want you to understand before we go any further is this: the pressure is a tactic. It is not a favor. And if you respond to it the wrong way, the consequences can follow you for years. Some employers go even further. They label workers as independent contractors to avoid workers' comp coverage. That is a whole separate issue that we covered in another video on this channel. But the underlying strategy is identical. Change a label, eliminate a liability, know the pattern. Under North Carolina workers' comp law, your employer does have a legal right to offer you light duty work once your treating physician releases you for restricted activity. If that job offer falls within your physical restrictions and you refuse it without a valid reason, the North Carolina Industrial Commission can suspend your wage replacement benefits. That is the law under 9732. It is real, and ignoring it has real consequences. But here's what the insurance company will never explain to you. The job must qualify as what North Carolina workers' comp law calls suitable employment. Suitable means the position falls within every restriction your treating physician has set. Not close, not mostly, actually within them specifically and completely. A light duty job can still qualify as suitable employment in North Carolina, even if it pays less than your pre-injury wage. The statutory definition is under 97.2-22, primarily on whether the work falls within your medical restrictions and physical capacity, not on pay comparability. So if you were earning $28 an hour before your injury, and the light duty offer pays $12 an hour, you may be entitled to a partial wage loss benefit on top of your reduced pay. That money disappears if you do not know the rule exists. The insurance company counts on you not knowing this distinction. The light duty trap. Here's a scenario I have seen more times than I can count in North Carolina workers' compensation cases. The employer sends over a light duty job description. It says sedentary work, clerical support, or administrative duties. It sounds reasonable on paper. The worker, worried about losing benefits, comes back to work. But when they arrive, the actual job involves standing at a service counter for 6 hours, reaching overhead to pull supplies from shelves, or spending the shift on a concrete floor with no ergonomic accommodations and no chair. Nothing in the written offer technically lied. The gaps were just left out. If you take that job and return to work, you push through the pain because you're afraid of losing your check or losing your job and re-injure yourself on day 3 of that work. Your employer and the insurance carrier will point to that written offer that said light duty and argue that you were medically cleared for that work. That argument becomes very complicated when you are back in for additional surgery. And a re-injury does not only mean more medical bills, it means the insurance company now has an argument that the second event is a separate injury, distinct from your original claim. It means your permanent disability rating may need to account for a different injury profile altogether. It means the story of your case gets significantly harder to tell, and the permanent disability payment you have earned gets harder to protect. Step 4, how to respond when the offer comes in. When you receive a light duty offer, do not respond verbally. Take these steps in this order. First, get the complete job description in writing, not a verbal summary over the telephone. A written document that specifies every physical requirement, standing and walking time per shift, lifting requirements, reaching requirements, hours, schedule, pay rate. If they still will not put it in writing, that tells you something. Second, take that written description to your treating physician. Do not ask your employer to schedule this appointment. You go on your own. Show the doctor the full description and ask directly whether or not every requirement in this document falls within my current medical restrictions. Get that answer documented in your medical record in writing with a date. Third, if your treating physician says any part of the job exceeds your restrictions, do not accept the offer. Send a written statement to your employer stating that you are declining based on your doctor's medical opinion, and attach or reference the physician's documentation. Keep a copy of it and make sure to date it. Send it in a way that creates a record, such as an email or a certified mail. That written trail is your protection if the insurance company tries to use your refusal to cut off your benefits. Without it, the case becomes your word against theirs. About 3 weeks after Marcus declined the light duty offer, his employer sent him a letter. He received a written warning for an attendance issue that had never come up before in his employment history. 6 weeks after that, he was laid off. North Carolina's Retaliatory Employment Discrimination Act, known as REDA, protects workers in exactly this situation. Under 9521 of the statutes, it is illegal for an employer to discharge or otherwise discriminate against any employee because the employee filed a workers' comp claim, received workers' comp benefits, or even testified in a workers' comp hearing. Declining an unsuitable light duty offer is a direct exercise of your rights under the workers' comp system. One critical procedural fact that most injured workers never hear until it is too late. If you believe that your employer has retaliated against you, a REDA complaint must be filed with the NC Department of Labor within 180 days of the Retaliatory Act. That clock starts running from the date of the adverse action, not from when you realize what's been done to you. If you wait longer than 180 days, you may lose the right to pursue that claim entirely. But the law only protects you if you document what is happening in real time. If you have no record of the supervisor who called you 4 times in 3 weeks, no written record of the light duty offer and your response, no record of the timeline between your refusal and the adverse action, then your employer has cover to claim that any discipline or termination was for unrelated reasons. Write everything down. Keep a personal log with dates, times, who said what and when. Save every voicemail. Respond to all pressure in writing, even if you only need the job description in writing before you can evaluate it. And if you are terminated, demoted, or written up after asserting your rights in a workers' comp case in North Carolina, call a workers' comp attorney immediately. That is a separate legal claim with its own remedies, and the clock starts running the moment the adverse action happens. If your employer has been pushing you to come back before your doctor has cleared you, I want to hear what that pressure looked like. Drop your situation in the comments below. Other injured workers in North Carolina are reading these comments, and your experience may help someone else recognize what is happening to them. The highest stakes consequences of returning to work before you're fully ready is what it does to your permanent partial disability determination. In North Carolina, when you reach maximum medical improvement, your treating physician assigns a disability rating. That rating, combined with which body part was affected, determines how many weeks of permanent partial disability compensation you're entitled to under 9731. For a back injury, depending on the rating and your average weekly wage, that range can be anywhere from a few $1,000s to tens or hundreds of thousands. The difference between a well-documented claim and a compromised one can easily be 20 to 40,000 or more. If you return to work too soon, re-injure yourself, and now you have a more complex injury profile than you would have had you healed properly, the original injury gets buried in the complications that followed. The insurance company disputes which limitations came from the first event and which came from the second. Your treating physician has to untangle a recovery that was interrupted. The permanent rating becomes a battleground. I have watched this sequence play out dozens of times over 40 years in North Carolina workers' comp. The pressure to return felt like a practical necessity in the moment. The consequences stretched out over the entire life of the claim. Knowing your rights before you answer the phone call is very important. If this sounds familiar, watch this next video. I made a video on 5 dirty tricks insurance companies use against injured workers in North Carolina, and this return to work pressure is part of that playbook. If you need to talk through your claim, King Law Firm is in the description below. 3 offices across Eastern North Carolina, available for a free consultation. And if your employer has been pushing you back too soon, tell me in the comments below.